Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Now today, ladies and gentlemen, we'll be providing another installation into our Anti-Federalist Papers series going on number 32. So if you haven't gone back and watched 1 through 31, and if you don't see 31, don't worry, it's combined with number 30. That's how the historical record shows them to be. It's a little too difficult to see exactly where 30 and 31 distinct or separate. But anyway, go ahead and go back and watch through 1 through 31, because understanding the Anti-Federalist Papers, in addition to the Federalist Papers, will provide you a very advantageous, well-rounded understanding of the U.S. Constitution, and understanding the U.S. Constitution will absolutely be necessary if you intend to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. There are multiple institutions from which you can get a paper and digital copy of the Anti-Federalist Papers. Go ahead and get both formats just in case you can't access one or the other for whatever infinite number of reasons. While you're at it, if you haven't already, go ahead and get a paper and digital copy of the Federalist Papers so you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. Excellent. So number 32 is titled Federal Taxation and the Doctrine of Implied Powers, Part 1. This is a powerful rebuttal of Hamilton. The logic of Brutus can be found in a Supreme Court decision of 1819, McCulloch versus Maryland. Yes, we will be going over that in our SCOTUS Blunders series, so be sure to be ready for that. Taken from Brutus' fifth essay, published in the New York Journal on December 13th, 1787. So Brutus says this. And you have to remember, the Anti-Federalists use pseudonyms because the Federalists frequently said, you're going to adopt this Constitution or you're going to face severe ramifications. Hamilton overtly said at one point, the states are going to comply or they will die. This Constitution considers the people of the several states as one body corporate and is intended as an original compact. It will therefore dissolve all contracts which may be inconsistent with it. This not only results from its nature, but it is expressly declared in the 6th article of it. In case you have forgotten, the 6th article to the U.S. Constitution includes the Supremacy Clause. The design of the Constitution is expressed in the preamble to be, quote, in order to form a more perfect union, to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and posterity. These are the ends this government is to accomplish, and for which it is invested with certain powers. Among these is the power, quote, to make all laws which are necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. It is a rule in construing a law to consider the objects of a legislature had in view in passing it, and to give it such an explanation as to promote their intention. The same rule will apply in explaining a constitution. The great objects are then declared in this preamble in general and indefinite terms to provide for the common welfare, and an express power being vested in the legislature to make all laws which shall be necessary and proper for carrying into execution all the powers vested in the general government. Oh, but we don't have to worry about this because even Hamilton in the Federalist Papers said, well, the necessary and proper clause isn't a carte blanche permission slip to the federal government. No, no, no. It still means necessary and proper pursuant to the U.S. Constitution, pursuant to the powers specifically enumerated in Article 1, Section 8. It would be so absurd to think that the federal government or any actor thereof would think otherwise, would think that the necessary and proper clause it provides for anything other than all actions from the federal government have to be made in compliance to the U.S. Constitution. How silly of you to think that, Anti-Federalist. Go ahead and ask the question for yourself. Was it so absurd to be so deathly concerned of that legalese and ambiguity? I won't answer for you. I'll let you answer what I guarantee we all provide the same answer. Or I will let you answer with the answer I can almost guarantee we all give. There we go. and an express power being vested in the legislature to make all laws which shall be necessary and proper for carrying into execution all the powers vested in the general government. The inference is natural that the legislature will have an authority to make all laws which they shall judge necessary for the common safety and to promote the general welfare. This amounts to a power to make laws at discretion. No terms can be found more indefinite than these, and it is obvious that the legislature alone must judge what laws are proper and necessary for the purpose. It may be said that this way of explaining the Constitution is torturing and making it speak what it never intended. This is far from my intention, and I shall not even insist upon this implied power, but join issue with those who say we are to collect the idea of the powers given from the express words of the clauses granting them, and it will not be difficult to show that the same authority is expressly given which is supposed to be implied in the foregoing paragraphs. Good grief. Pointing out the exact problem. I mean, that whole paragraph, though it's long, that whole paragraph is incredibly important to note. In the first article, 8th section, it is declared, quote, that Congress shall have power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States. In the preamble, the intent of the Constitution, among other things, is declared to be to provide for the common defense and promote the general welfare. And in this clause, the power is in express words given to Congress, quote, to provide for the common defense and general welfare. And in the last paragraph of the same section, there is an express authority to make all laws which shall be necessary and proper for carrying into execution this power. It is therefore evident that the legislature under this Constitution may pass any law which they may think proper. No, 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 Hamilton said. Proper means pursuant to the U.S. Constitution, pursuant to the powers enlisted in Article 1, Section 8. It's so silly to think otherwise. It is absurd. It is unreasonable. Do you agree with Hamilton, or do you agree with this rightfully weary anti-federalist, Brutus? Brutus was brilliant. It is true the 9th section restrains their power with respect to certain subjects, but these restrictions are very limited, some of them improper, some unimportant, and others not easily understood, as I shall hereafter show. It has been urged that the meaning I give to this part of the Constitution is not the true one, that the intent of it is to confer on the legislature the power to lay and collect taxes, etc., in order to provide for the common defense and general welfare. To this I would reply that the meaning and intent of the Constitution is to be collected from the words of it, and I submit to the public whether the construction I have given it is not the most natural and easy. But admitting the contrary opinion to prevail, I shall nevertheless be able to show that the same powers are substantially vested in the general government by several articles in the Constitution. It invests the legislature with authority to lay and collect taxes, duties, imposts, and excises in order to provide for the common defense and promote the general welfare, and to pass all laws which may be necessary and proper for carrying this power into effect. To comprehend the extent of this authority, it will be requisite to examine first what is included in this power to lay and collect taxes, duties, imposts, and excises. Second, what is implied in the authority to pass all laws which shall be necessary and proper for carrying this power into execution? These are brilliant questions. Questions that the Supreme Court themselves have gotten brutally wrong. Third, what limitation, if any, is set to the exercise of this power by the Constitution, and instead of the U.S. Supreme Court upholding their oath, upholding their sole purpose, they ruled in favor of expanding the government, which, pursuant to contra proferentum, they cannot do. The Supreme Court has to always, whenever there's legal ambiguity, whenever there's confusion of terms, always favor the citizen. Always. Every single time. They've almost never done that. Never. First, to detail the particulars comprehended in the general terms, taxes, duties, imposts, and excises would require a volume instead of a single piece in a newspaper. Indeed, it would be a task far beyond my ability, into which no one can be competent unless possessed of a mind capable of comprehending every possible source of revenue, for they extend to every possible way of raising money, whether by direct or indirect taxation. Under this clause may be imposed a poll tax, a land tax, a tax on houses and buildings, on windows and fireplaces, on cattle, and on all kinds of personal property. Doesn't that sound familiar? It extends to duties on all kinds of goods to any amount, to tonnage and poundage on vessels, to duties on written instruments, newspapers, almanacs, and books. It comprehends an excise on all kinds of liquors, spirits, wines, cider, beer, etc., and indeed takes in duty or excise on every necessary or conveniency of life, whether of foreign or homegrown or manufactory. I specialize in tax law. I know exactly what he's talking about here. The tax code is tens of thousands of pages long. If you dedicated your whole life to just reading the tax code every single day, 24/7, you would not be able to finish it before you were lying on your deathbed. That's exactly what he's talking about here. And how do you apply? How do you as a citizen comply with that? You can't. It's not possible, which is why the laws inherent in the idea of the rule of law have to be simple and concise and direct. In short, we can have no conception. I'm sure he's about to say that very same thing. In short, we can have no conception of any way in which a government can raise money from the people, but what is included in one or other of these general terms. We may say then that this clause commits to the hands of the general legislature every conceivable source of revenue within the United States. Not only are these terms very comprehensive and extend to a vast number of objects, but the power to lay and collect has great latitude. It will lead to the passing of a vast number of laws which may affect the personal rights of the citizens of the states, expose their property to fines and confiscation, and put their lives in jeopardy. No, the founders did not give the authority of eminent domain to the federal government. It's been argued many times in court. The U.S. Supreme Court's even upheld eminent domain. The founders did not even implicitly, give the authority of eminent domain to the federal government. It opens a door to the appointment of a swarm of revenue and excise collectors to prey upon the honest and industrious part of the community and eat up their substance. Second, we will next inquire into what is implied in the authority to pass all laws which shall be necessary and proper to carry this power into execution. If I didn't make very clear that connection I was making with eminent domain, that's exactly what he's saying here. This vague, vast taxing authority will put the property of innocent people in jeopardy. If this founder doesn't even permit for the equivocation that taxing can possibly lead to confiscation of property, disobeying taxes can't lead to a confiscation of property, then there's no reason to believe, there's no rationale to then argue, well, if the government can't take it from, because you're disobeying taxation, well, then they can take it just because they want to through eminent domain. That doesn't follow. If they can't take it, even though you're disobeying taxes, they can't take it because they simply want to. Let me know if you have questions on that in the comments. So, second, we will next inquire into what is implied in the authority to pass all laws which shall be necessary and proper to carry this power into execution. It is, perhaps, utterly impossible fully to define this power. The authority granted in the first clause can only be understood in its full extent by descending to all the particular cases in which a revenue can be raised. The number and variety of these cases are so endless, and as it were infinite, that no man living has, as yet, been able to reckon them up. The greatest geniuses in the world have been for ages employed in the research, and when mankind had supposed that the subject was exhausted, they have been astonished with the refined improvements that have been made in modern times, and especially in the English nation, on the subject. If, then, the objects of this power cannot be comprehended, how is it possible to understand the extent of that power which can pass all laws which shall be necessary and proper for carrying it into executions? It is truly incomprehensible. Take note of that. You know what? Let's go ahead and highlight that whole paragraph. If, then, the objects are not finite, are not comprehensible, then the power is infinite. A case cannot be conceived of which is not included in this power. It is well known that the subject of revenue is the most difficult and extensive in the science of government. It requires the greatest talents of a statesman and the most numerous and exact provisions of a legislature. The command of the revenues of a state gives the command of everything in it. He that has the purse will have the sword, and they that have both have everything. So that the legislature, having every source from which money can be drawn under their direction, with a right to make all laws necessary and proper for drawing forth all the resource of the country, would have, in fact, all power. Gosh, does that not sound familiar? Were I to enter into the detail, it would be easy to show how this power in its operation would totally destroy all the powers of the individual states. But this is not necessary for those who will think for themselves, and it will be useless to such as take things upon trust. Nothing will awaken them to reflection until the iron hand of oppression compel them to it. Highlight that. If you don't understand the vastness of the power, you're only going to understand it after it's too late. Or the danger and the vastness of power that's granted by the necessary and proper clause. Then you'll only understand it whenever it's too late. I shall only remark that this power given to the federal legislature directly annihilates all the powers of the state legislatures. There cannot be a greater solecism in politics than to talk of the power in a government without the command of any revenue. It is as absurd as to talk of an animal without blood, or the subsistence of one without food. Now the general government, having in their control every possible source of revenue and authority to pass any law they may deem necessary to draw them forth or to facilitate their collection, no source of revenue is therefore left in the hands of any state. Should any state attempt to raise money by law, the general government may repeal or arrest it in the execution, for all their laws will be the supreme law of the land. If, then, anyone can be weak enough to believe that a government can exist without having the authority to raise money to pay a doorkeeper to their assembly, he may believe that the state government can exist should this new constitution take place. It is agreed by most of the advocates of this new system that the government which is proper for the United States should be a confederated one, that the respective states ought to retain a portion of their sovereignty, and that they should preserve not only the forms of their legislatures, but also the power to conduct certain internal concerns. Thank goodness that was maintained. How far the powers to be retained by the states are to extend in this is the question. We need not spend much time on this subject, as it respects this Constitution, for a government without power to raise money is one only in name. It is clear that the legislatures of the respective states must be altogether dependent on the will of the general legislature for the means of supporting their government. The legislature of the United States will have a right to exhaust every source of revenue in every state, and to annul all laws of the states which may stand in the way of effecting it. Unless, therefore, we can suppose the state governments can exist without money to support the officers who execute them, we must conclude they will exist no longer than the general legislatures choose they should. Indeed, the idea of any government existing in any respect as an independent one, without any means of support in their own hands, is an absurdity. If, therefore, this Constitution has in view what many of its framers and advocates say it has, to secure and guarantee to the separate states the exercise of certain powers of government, it certainly ought to have left in their hands some sources of revenue. It should have marked the line in which the general government should have raised money, and set bounds over which they should not pass, leaving to the separate states other means to raise supplies for the support of their governments and to discharge their respective debts. It does place one limitation. The Constitution, the U.S. Constitution, directly, explicitly, and eternally forbids capitation taxes. So, the individual income tax, completely unconstitutional, even with an amendment. To this, it is objected that the general government ought to have power competent to the purposes of the Union. They are to provide for the common defense, to pay for the debts of the United States, support foreign ministers, and the civil establishment of the Union, and to do these, they ought to have authority to raise money adequate to the purpose. On this, I observe that the state governments have also contracted debts. They require money to support their civil officers. If they give to the general government a power to raise money in every way in which it can possibly be raised, with a control over the state legislatures as to prohibit them, whenever the general legislature may think proper, from raising any money, the states will fail. It is again objected that it is very difficult, if not impossible, to draw the line of distinction between the powers of the general and state governments on this subject. The first, it is said, must have the power to raise the money necessary for the purposes of the Union. If they are limited to certain objects, the revenue may fall short of a sufficiency for the public exigencies. They must therefore have discretionary power. The line may be easily and accurately drawn between the powers of the two governments on this head. The distinction between external and internal taxes is not a novel one in this country. It is a plain one and easily understood. The first includes impost duties on all imported goods. This species of taxes, it is proper, should be laid by the general government. Many reasons might be urged to show that no danger is to be apprehended from their exercise of it. They may be collected in few places, and from few hands, with certainty and expedition. But few officers are necessary to be employed in collecting them, and there is no danger of oppression in laying them, because if they are laid higher than trade will bear, the merchants will cease importing or smuggle their goods. Pretty fair conclusion. Pretty fair inference. We have therefore sufficient security arising from the nature of the thing against burdensome and intolerable impositions from this kind of tax. The case is far otherwise with regard to direct taxes. These include poll taxes, land taxes, excises, duties on written instruments, on everything we eat, drink, or wear. They take hold of every species of property and come home to every man's house and pocket. These are often so oppressive as to grind the face of the poor and render the lives of the common people a burden to them. The great and only security the people can have against oppression from this kind of taxes must rest in their representatives. If they are sufficiently numerous to be well informed of the circumstances and have a proper regard for the people, they will be secure. That's a lot of trust to place in a politician. The general legislature, as I have shown in a former paper, will not be thus qualified, and therefore, on this account, ought not to exercise the power of direct taxation. If the power of laying imposts will not be sufficient, some other specific mode of raising a revenue should have been assigned to the general government. Many may be suggested in which their power may be accurately defined and limited, and it would be much better to give them authority to lay and collect a duty on exports, not to exceed a certain rate per cent, than to have surrendered every kind of resource that the country has to the complete abolition of the state governments, and which will introduce such an infinite number of laws and ordinances. What were we just talking about? And if you dedicated every single day of your life to reading the tax code, the U.S. tax code, 24/7, 365, you would not complete it, even when you're lying on your deathbed. An infinite number of laws and ordinances, fines and penalties, courts and judges, collectors and excisemen, that when a man can number them, he may enumerate the stars of heaven. Signed, Brutus. And again, you have to remember, with the Anti-Federalists, they're predicting this before the U.S. Constitution is ever even implemented. So the founders knew, and they just didn't care. But if you have any questions about what was said in number 32, maybe questions about what was said in the preceding papers, or if there's a topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.